Supreme Court hearing today arguments on affirmative action in college admissions.
Affirmative action.
Affirmative action.
Affirmative action.
Affirmative action.
Let's be honest, no one likes college admissions. And with the Supreme Court case determining its fate right now, it's time to talk about one of college admissions' most contentious aspects, affirmative action.
Race for some highly qualified applicants can be the determinant factor, just as being an oboe player in a year in which the Harvard Radcliffe Orchestra needs an oboe player will be the tip.
We did not fight a civil war about oboe players. We did fight a civil war to eliminate racial discrimination, and that's why it's a matter of considerable concern.
We've been hearing the term affirmative action a lot, but what exactly is affirmative action? Today, affirmative action is most commonly known as the practice of favoring individuals belonging to marginalized groups previously discriminated against when it comes to higher education. However, this wasn't always the case. To understand the foundational basis of affirmative action, we have to look at the 14th Amendment. The 14th Amendment states that no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. During Reconstruction after the Civil War, the United States federal government had to figure out a way to help formerly enslaved people start their lives as official citizens in accordance with the 14th Amendment. One way they did this was through the Freedmen's Bureau. The Freedmen's Bureau sought to provide resources such as food, shelter, and clothing, as well as legal documentation to refugees and formerly enslaved people so that they could more easily assimilate into their new lives. By providing resources that would ensure equal protection for refugees and newly freed black citizens, the government was able to integrate new citizens into American society. It proved to be an extremely effective program that was unfortunately abolished in 1872 when Reconstruction ended. However, many scholars consider the Freedmen's Bureau to be an original affirmative action program because it sought to increase diversity through the granting of basic rights in accordance with the Constitution. So how did it become synonymous with college admissions? In 1961, the Kennedy administration started the Committee of Equal Employment Opportunity. The Committee of Equal Employment Opportunity sought to combat racial discrimination by implementing policies that would ensure diversity in the workplace and offer better opportunities for marginalized communities. Within the 14th Amendment is a very important clause, the Equal Protection Clause. Civil rights cases like Brown versus the Board of Education, which desegregated schools, and Title IX, which prohibited discrimination on the basis of sex in higher education, used this clause as a constitutional basis for their Supreme Court rulings. But with all major legal changes, real implementation of new laws and rulings takes time. While these cases made a difference in higher education by increasing diversity minimally, college admissions didn't start making an effort to increase diversity until the passage of the Civil Rights Act of 1964. The Civil Rights Act of 1964 required federal institutions receiving federal funding to document their affirmative action practices. This incentivized colleges to accept more students of color so that they could receive federal funding. For the most part, affirmative action has done exactly what it intended to do. According to the United States Bureau of Labor Statistics, 45% of college students today are people of color, and the number is only rising. So why is affirmative action controversial if it brought diversity into higher education? Well, take the latest pending Supreme Court case, Students for Fair Admissions Incorporated versus President and Fellows of Harvard College, in which Asian American students argued that Harvard University favored white students over Asian students in the admissions process. The last time the Supreme Court ruled on affirmative action was in Grutter versus Bollinger in 2003. After the University of Michigan Law School denied admission to Barbara Grutter, a white female, she sued, arguing that she was rejected because the law school used race as a predominant factor. The Supreme Court disagreed, ruling that a narrowly tailored use of race in admissions decisions to further a compelling interest was okay. However, Justice Sandra Day O'Connor also wrote in the majority opinion that the court expects that 25 years from now, the use of racial preferences will no longer be necessary to further the interests approved today. Gratz versus Bollinger, a separate case decided the same day as Grutter, said pretty much the same thing. An affirmative action system was legal but could not automatically award points solely based on race, and that race had to be phased out of admissions eventually. But let's go back further to the first case that dealt with affirmative action, which was the University of California versus Bakke of 1978. Although the Supreme Court outlawed segregation in schools in 1954 through Brown, UC was setting aside 16 of 100 seats for their medical school for minority students. The Supreme Court ruled that while affirmative action was permissible, explicit racial quotas were not, and ordered that Baki be admitted into the program based on his grades and background. Today's opponents of affirmative action argue that other marginalized communities, such as the Asian American community, are being discriminated against in college admissions, therefore violating the Equal Protection Clause of the 14th Amendment.
If we were skeptical of the institution, we might suspect that they really wanted to discriminate and they wanted cover. So they give themselves a plausible story.
To the extent that the courts allowed this, it provides you with a way to discriminate. The personal rating is particularly subjective. Asian Americans have unexplainably low personal ratings. And when I read the files myself, I could see it.
And the other issue posing affirmative action is whether it is done properly in this day and age. Opponents of affirmative action argue that it's being used to help second and third generation college students instead of reaching marginalized communities that lack the resources for college preparation. Many opponents, such as the Students of Fair Admissions, have proposed plans that would increase economic diversity while making the admissions process race neutral. While 67% of Harvard students are in the top 20% when it comes to income, Harvard has said that they have programs to increase access and that SFFA's proposed plans would do more harm than good. Proponents of affirmative action argue that without affirmative action, the enrollment of minorities in schools like Harvard would drop, leading to less diversity in education and beyond.
What we know is that at elite colleges and universities in this country, Black Americans make up only 5% of students enrolled with affirmative action. So it's kind of hard to prove that large numbers of white Americans are being discriminated against when Black and Latino students are still underrepresented in four-year institutions.
While this is an issue tackled by both sides, the whole system of college admissions is under strict scrutiny. Should students with alumni parents, called legacies, be given a leg up? Can public school students compete with private college prep schools? What exactly does holistic admissions mean? While colleges like Harvard say that affirmative action is part of many of the programs it employs to fix societal inequities,
we pretend that college admissions is based on a meritocracy, that every student is coming from an even playing field, and the best students, the students who work the hardest, are the ones who get the highest test scores and have the best grades and should get in. But we know that that is fundamentally untrue.
Opponents say that it contributes to the inequity created by all of these programs.
Here's my guess. If you just admitted the kids who were the strongest students, Harvard would be 50 or 60% Asian. If they just did it straight up by academic performance, there wouldn't be enough room for the sons and daughters of alumni.
This is what the Supreme Court is ultimately deciding with this case. So, what are your thoughts? Do you think affirmative action has served its purpose and is no longer needed? Or do you think that affirmative action is still important and needs to remain in college admissions? Let us know below. Thank you.